us, we have with us, we have Advocate.Jinal Shah, the speaker over for this particular session. On behalf of S.S.T College, I'm thankful to founder principal, Dr. J.C. Purswani sir, IQC coordinator Khushbu Purswani ma'am, and HOD Assistant Professor Pazma madam, for organizing such a particular session on the World IPR Day, on which has been celebrated worldwide on 26th of April 2022. The awareness related to IPR is the need of the day, because many things related to copyright, patents, trademark, design is every day coming up, because the reason is that we are into the electronic era, we are into the e-contracts part. So I'm welcoming as Advocate.Jinal Shah. Madam, the session is over to you. Please speak about the IPR. Thank you from my side.
Thank you so much. Thank you so much for a fabulous introduction. Firstly, let's go ahead and thank all the artists, thank each and everyone who are involved in intellectual property, making it a big success. It's a booming era, as we all know. And in this business scenario and in this world right now that we are living, technology is the most important, is the biggest intellectual property that we have right now. So a career in intellectual property is definitely a booming one. And further moving ahead, congratulations each and everyone for being present over here and taking out your time for us right now. So intellectual property, the history of, so is the PPT on right now? Next slide. So firstly, what is the history and what is the meaning of intellectual property that we all need to know? The meaning of intellectual property can be traced to the ancient usage of stamps and bricks or by the Roman brick makers for the purposes of identification, and even before to the time when the leaders of ancient Greek city and suburbs approved the monopoly of 1 year cooking an enjoyable dish to the creator. So in this era that we are living right now, intellectual property plays an important role. And even if you don't know, there is intellectual property that you're using right now in your hands. Starting from your mobile phone, the dresses that you wear are designed by someone. The mobile phone that you're using have the patents, copyrights, trademarks, and everything. The fan that you're sitting inside have the design registered with some authority. Everything that you use right now, the patches, the handkerchief, even an handkerchief, the design of it is an intellectual property of some person who have created it. So it is the time, it is the era that we are living in right now, that the artist or the creator or the innovator or the founder of any particular thing is considered as a property for that person who have put in their efforts into creating that property and being a useful thing for the society as a whole. So that person gets a monopoly over the creation that they have made out. So basically, intellectual property means something that is intellectually applied, that is created by intellect, and that is serving the society and that benefits the maker. Next slide. So in India, as we stay right now, so what are the laws that govern intellectual property? We need to know that, so that tomorrow, if we create some property, may it be a writing, may it be a document, may it be a new design of your notebook, may it be words that you are speaking, be it a poetry, be it a music that you singing, be it a composition of a music. So each and everything is governed by some or the other intellectual property. So it starts from long back, since it's been like around 200 years that the intellectual property have been started, but the laws have started in India since 1957. First is the Patent Act, second is the Copyrights Act, third is the Design Act, fourth is the Trademarks Act, fifth is the Geographical Indications and Goods Protection Act, fifth is the Semiconductor Integrated Circuits Layout Design Act, fourth is the Protection or Plant Varieties and Farmers Rooms Act. Fifth is the Botanical Diversities Act. So now you might be wondering, chalo theek hai, we know that exist. You must be wondering, theek hai, copyright, we have heard it of in many YouTube channels as we are on YouTube right now. So it's a very common thing, everyone know about it. Then comes the Designs Act. Okay, you wear designer clothes. Manish Malhotra is there that we all know about, that who of keeps uh, getting copyrights on the designs that he creates. Then trademarks, we definitely know Apple logo and things like that. But what is geographical indications? So you know Assam ka chai. We all know Kolhapuri chaku. Kolhapuri chappal. We all know the kattas from north side. We all know about some of the other thing that is special to a geographical area that cannot be grown. We know of the strawberries of Kashmir. So these are the geographical indications and goods that are produced in a particular geographical area that gives that particular area or a territory or a state or a region its speciality that cannot be grown somewhere else, or a particular product that cannot be a specialty of some other state or a region. So it is covered under this particular. Then comes the semiconductor circuits layout design. So the mobile phone or a laptop or a TV that you're using right now, all the smart devices that we are using right now, all these smart devices can be covered into this one, the 2000 Act. So why is it necessary? It takes a lot of learning, lot of mathematics, lot of experience, lot of permutations and combinations to create a device that you are wearing right now, or that you are holding in your hands right now. That, as we all know, there were telephones that used to be a size of a human that are now compressed into a size of a hand. So how is it possible? It is because of the circuits that are created by some innovator with its intellectual property. So it should be covered, right? It should get the monopoly and the advantage of it, because once it is made, everyone else would start using, and the person who have made it does not get the advantage. So it is covered under this particular act. Then comes the botanical varieties. And before that, we have to see the protection of plant varieties and farmers act. So why is it necessary that plants have to be protected? We are living in such a technical era that we can grow plants in any conditions. We have greenhouse system. We have many systems that have a format to grow plants in any region that we want to. Then why is it necessary to cover that? Because it has now it's a time that we all are considering the environment protection. So when a plant of a particular region or a plant that is grown by a particular person is beneficial to society, it should be covered and it should be protected in a way that these varieties are limited and no other person can duplicate it without a justifiable reason. And the person who finds out, this is a kind of encouragement for people to discover the varieties of plants that are existing on this earth, so that the environment can be protected and the goods that we get from the plant can be identified, because there are many species that are getting extinct day by day. So all those need to protect them. Then it's about the Botanical Diversities Act. So this is for the protection of the rights that who can modify the flowers, who can modify the house plants. So this act basically provides protection to those plants that are not actually discoverable, but that are innovative plants. So protecting this kind of innovation is also necessary. Even if we remain in a technical era, we are humans. We require a new kind of food to eat every day. We require fresh energy, fresh air. So all these kinds of protection to plants actually help the society to grow in both the ways. Going ahead.
Very true, Jinal. Related to you rightly spoke about the Kashmiri peta or the Kolhapuri chappal or the strawberries of Mahabaleshwar. You had rightly spoken about the various layouts, designs of the circuit which are available in the cell phone or in the LCD or the particular TVs.
Smartwatch
Related
also
to
that we use.
smartwatch also, real. Madam, you speak on about the plant varieties which are available in the market to get protected. The government of India is starting with the initiative related to plant varieties. Related to Biological Diversity Act or related to the farmers, their rights has to be protected. So if you see this particular in India, the particular areas in which these particular acts are being incorporated, every now and then the government of India are going for the copyrights. So rightly so about the YouTube channel, the copyright has been done. Coming to the next slide, ma'am.
So in India, which ministry takes care of this copyrights? So the Ministry of Commerce and Industry Department that takes care of all the intellectual properties that are there in India. India was known to be Sone ki Chidiya back then, but in this so long time, we have all noticed that India has been exploited for its spices. India has been exploited for its labor, the intellectual labor. So there are many perks that the foreign countries give to Indians so that they migrate to other countries and serve their intellect over there. So government of India is right now taking initiatives that the intellect that is there in India stays in India and feeds in India. So the Ministry of Commerce and Industry Department is likely making making policies and it is controlled by the Controller General of Patents, Designs and Copyrights and Trademarks. So sorry. Firstly, there is Patents and Designs Office. Secondly, there is Trademark Registry. Thirdly, there is Geographical Indication Registry. And fourth is the Patent Information System. So the plants and the varieties that we spoke about just right now is covered under public patent information system, and all the other three technically supports the business class mainly to keep the economy in flow. And the fourth kind is to keep the environment in flow and give benefits to people who curate environment and not just for their business purpose. So the government of India, as Sir rightly mentioned, is taking quite initiative and taking a lot of efforts into balancing the society for humans and for economic developments both. So
So,
firstly, yes, sir.
you are quite aware that the government of India has started with the Patents Act, wherein if it's a new product which has been innovative and is beneficial to everyone, the original originator can go to the patents office and get their patent registered. And after, if it is
Absolutely.
beneficial to everyone, the registrar of the patent will give them the license to use it for, ma'am, for how many years it's allowed for patents?
It's for 20 years.
20 years. So the this particular design, this particular product, the drug like Covaxin or the Covishield, if the manufacturer or any of the medicine wants to get the patent registered, they have to go to the patents office, which is there in the metropolitan office. And after the registrar has been satisfied with the documentary evidence which is produced, and looking into this particular, they will give the license to get the patents registered. And those
Exactly.
persons who are interested for becoming TMA, that is called trademark registered agents, they can go to the trademark office and they get their patent trademark registered.
Trademarks registered.
Yeah, thank you, ma'am. Thank
Absolutely.
you. Yeah.
So what is patents in the first place? The patents are inclusive right granted to anyone who invents new or improves the product or process in by the or process. So it is given by the government. Absolutely any intellectual property right is always granted by the government to a particular person. No person like me, I cannot grant any right to sir that this is your intellectual property right. No, this is not possible. It is only the government who can grant the right. So patents are exclusive rights. Now, if an engineer comes up with an innovative kind of a drone that can that can actually spread seeds around the farm, or this kind of a drone that can not only just capture photos, images, and videos, can also capture sounds. And apart from that, it can also deliver products at the same time. So that's an innovation that is not existing in market right now. So this is an intellectual property. So there has to be an innovation that is necessary. There has to be, and it has to be for benefit of the public. Now, if there is an existing kind of a gun that is AK-47, and then you name something else as AK-48, and yes, this gun can directly shoot when you target a person, that cannot be covered into patent unless and until it is a licensed and a government authorized gun. So if you go in an illegal format, then this cannot be applied. But if it is about a legal purpose, the purpose of the product should be legal and legitimate. It should not harm the society. It should not create threat to the society in any manner. So during a patent application, we have to mention each and everything. Keep in mind that the particular kind of product does not exist in market already. And if it exists, then there is a kind of innovation that does not exist, or a kind of usage of the product that does not exist in the market right now. You curate if there is an umbrella, and till a certain period of time, the person did not know that the umbrella can be used as protection against sun as well. So if you bring such kind of a usage to umbrella, then yes, you can definitely register a patent on it. But if the usage is already in the market, public is already using, then that is not possible. So a usage of a simple thing in a different manner can also be patented. Then going ahead, patent provides protection to the invention of the owner of the patent. The patent, the protection is granted for a limited period. It is not that like it's for a lifetime that a person creates it and no one else can ever manufacture the product. No, it is not possible. The first thing is the purpose of intellectual property right is to give a benefit and a motivation to the innovators, so that the people who are here can actually find out new things, curate new things, and be beneficial to the society. And so it has to be for a limited time. And when the product is beneficial to the society, after a period of time, it is very necessary that the perks of the product can be enjoyed by every businessman, every industry available in the market. So it is granted for a limited period of time. For patents, it is 20 years of maximum protection. It is at the discretion of the government and the authorities that I just explained you. It is at their discretion that for how long the patents can be granted, or a patent is valuable for the innovator for how long. Because after that, once the innovator starts selling out the patented product, it gets into the market. So as we all know right now, we have this very big example of China, that it buys the products that are innovative, it deassembles it, it finds out which part, how it is made, how it is fixed, everything is found out by them. And then as soon as they find a chance that now the patent period is over on so and so product, they start producing it in bulk, and the society enjoys the benefit of it. So this is the manner in which the patents time limit is set, and they determine the time limit of it. Moving ahead, the patent protection means
Advocate.Jinal, my question was
that the innovation cannot be commercially made, used, distributed, or sold without the patent owner's consent. Yes, yes.
for discovery, patent is granted, or for invention, patent is granted?
For both, if there is an invention, or no, for discovery, the patent is not granted. For discovery, you can have a copyright.
Okay.
But patent is not granted.
Okay. Thank you.
Because an existing, a scientific, if there is something existing in the
Ma'am, your voice is muted.
Yeah, am I
okay.
audible right now?
Yeah, yeah.
So
you are
how
audible.
far was I audible, if I can ask?
Madam, please come again from the question. The
From
discovery in patent.
from the code.
Yeah.
Yes, yes. So the discovery cannot be patented. It can be copyright, or it can be covered. Mostly the discovery is of some biological product. So it can be covered into botanical or the other act that I mentioned, the farmers.
Okay.
If you curate a chemical from the earth, then that cannot be patented, because it is not an innovation. It should be an innovation of use or of type. Have I answered the question?
Yeah, ma'am. Yeah. Yes, ma'am. Please continue with this slide. Ma'am, please continue with this slide. Madam, please speak. Jinal, ma'am, please continue.
Yes, sir, yes, sir, yes. Sir.
Yeah.
Have I answered your question?
Yes, ma'am. Yes, ma'am.
So moving ahead, as I already mentioned, the innovation must have a useful purpose. It is just not that anything that is new can be patented. It should be useful to the society and beneficial to each and every person existing on earth. Secondly, the innovation must meet the legal definition of novel. It should be novel. It should not be that anything that is existing is just altered. The color of it is changed, the form, the shape of it is changed. Then it cannot be patented. It can definitely be copyright, but it cannot be patented. Thirdly, the innovation can't be something that anyone could invent. Now, I can make a kind of dal, and even sir can make the same kind of dal, but the basic thing is he does not know that a dal can be made out of so and so materials, but I know it. Then it cannot be, if he is a cook and even I am a cook, then this is not possible that it can be patented. It can be copyright, but it cannot be patented, because this is something given the provided the necessary materials and the necessary information, the same thing can be made by someone else easily. So this is the first thing. That's why only only design layouts, only things that are machines that are complicated machines. Then there are equipments that that need to have a particular diameter, particular edge, particular kind of point. Only those things are normally being patented, and not no every other thing that we use. So the invention must have patentable subject. Definitely, as we already said, that patentable subject includes all these things. Then there are main categories of patent. One is plant patent. That is the kind of uh, the kind of system that is required can be patented. Now, as we all might be knowing, this is now for people who follow the automobile industry. The Tesla has now created a factory that is totally automated. So the materials go in, the car is created, and a complete car comes out of the system. No human interaction is required. So it is in the process of making it. So this is the plant patent, that a particular kind of a plant that is developed over there can be patented. Obviously, it cannot be patented for a lifetime because it will be a monopolistic thing. Tesla is already 100 billion ahead of the second richest person. So he will definitely become the most, like, the god of the planet if such patent is given for a lifetime. So once he has made something, he should enjoy the benefits of its invention for 20 years, and later on it can be transferred. So a plant that is created for a particular, the format of making of a thing is made in an innovative manner such that it reduces the time, effort, and the finishing of it is increased. The quality of it increases by the plant, can be patented under this uh, act. Then comes the utility patent. Now, as I already mentioned, if you find out that the material that you have in hand can be utilized in some other manner that the world doesn't know about it right now, but you find out a different way of using it, can be patented. Then comes the design pattern. The design pattern is very in practical manner. If I say that obtaining a design pattern is very tough, and hence most of the time the person who is looking forward to obtain a design pattern do go ahead to file a copyright instead. An innovator who adds a distinctive element to the manufactured item. This mostly works in the space where it's about tools or a car or automobile kind of industry, or a technology that is information technology, wherein there are camera pop-ups coming out of the mobile phone. So there are no distinct camera that is appearing on the phone, and it goes inside the hardware. So that kind of design pattern can be easily obtained. But then the design, the frame is changed such that the battery usage reduces. So it gets difficult that the frame can be altered by every other person. Thoda thoda karke. So it becomes difficult to maintain this kind of a design pattern, and hence mostly the copyright patents is obtained in this scenario. What is patentable and what is not patentable is the biggest question that I often get. The one thing is
Madam,
patentable
it would
item.
be very difficult on the part of the register of patents to identify what is patentable and not patentable, because many drugs, many injectables, many designs are coming out in the market. So he would be much more worried. Am I right, ma'am?
Definitely, absolutely,
It requires a
absolutely,
lot of intellectuals to understand before
absolutely.
giving the permission to them.
So
Otherwise, there would be litigation going on around the world.
absolutely. For this purpose, actually, I would like to mention this topic firstly. When we go ahead to file a register of patent, we cannot just take the layout of our design, or we cannot just take the product that is the prototype that we have created before launching it into the market and show it to the registrar. We have to follow the complete procedure of it. We have to mention firstly how we have innovated the product. We have to prove the innovation that I have done it myself. It is not that I have copied it from somewhere, I have bought it from somewhere. And there are chances that I, staying in an urban area, have the knowledge that patents exist. But a person who is staying in a rural area does not have the knowledge but the intellect to create something like that. So the registrar and the offices keep this one point in mind before granting any patent, that the person who is bringing up the application to them is having the actual knowledge of the manufacturing of such patentable item. And in that we have to deeply explain them how we come across the idea of making it, how we have got in our creativity to make such a product, and then how we actually made the product, what were the difficulties. Sometimes they take interview. What were the difficulties that you faced while making the product? So all these have to be mentioned. And then we have to also mention that what are the loopholes in the in the product right now. What things it should do but it cannot do. Everything has to be mentioned. And after that, we have to disclose to them the usage of it to the society. Like if I launch this product in the society will accept it and the society want the product for their betterment. So each and everything is to be very much clarified. So actually, I think it's a task for the lawyers to prove that this item is patentable, and it's very easy for the registrar office to prove that, oh no, this is not patentable because this is not, because we as lawyers have failed to prove that this is beneficial for society. So as innovators, whoever is willing to go for patents, they have to keep in mind that they have a strong point that this can be used by the society and will be beneficial to the society. Also,
So,
there are questions that are sometimes asked that will this product be used as a equipment for for crimes? Will it be supporting criminals in any manner? So we have to keep those things in mind as well. The positives and negatives, both the things have to be examined.
so, ma'am, that means the registrar of patents who issues that particular license, he would be asking the positive, the negative part before applying for the
Yes,
patents, and those persons who are applying the patent should brief their advocates that this stand should be taken out while applying for getting the patents. Madam, if you see in
definitely.
India, the every now and then the new series of cell phones are launched, new watches, smart watches are being launched, or new drugs or new injectables forms syringe have been launched.
Hmm.
So every
Hmm.
now and then the registrar have to check his intellectual brain whether they
Yes,
issue to them the license or not, and rightly pointed out that the negative part should be explained to them, and the advocate should be briefed them to face any type of questions which will be raised by them. Madam, it's good that you are throwing
absolutely.
each and every aspect so that the on the world IPR day we are getting that abundance amount of knowledge from you.
Thank you so much. It's
Coming to
my
the next
pleasure.
slide.
Yes.
Yeah, ma'am.
What is patentable? Patentable. The subject matter of patentable can be. We can go ahead. I have already covered this point actually. Yeah. An applicant can receive a patent on categories such as business process, as I already explained, like the process in which every other person in the society is doing right now, and you have curated some other process that can minimize the time, efforts, or increase the productivity in any manner can be patented. The computer software that has a useful, concrete, and tangible purpose. So every software that is created is not patented, it's all mostly copyrighted. But software that is completely new, like iOS system, Android system, and there are many other systems. So Linux system, Ubuntu system, there are many other systems that are that can be patented, as they are altogether different computer softwares that run at a different level of capacities than computer hardware. As we all know, as I already mentioned, we used to have such big room size computers, man size phones, and now we have shrunk all of that into a small smartwatch that can help you talk, that can help you send messages, that can help you receive messages, that can help you do what not, like measure your blood pressure, measure your heartbeat. Each and everything is done by itself. So bringing such a big device into a small device requires such cost. So you can definitely patent a new innovative system that you have created in a computer hardware, like minimizing the size of the products. Electronics, every electronic that is created in a new manner can be patented. The fabrics and the base of it, there is a very thin line that goes into this. A patent can be obtained on a thin, there are yarns that makes cloths. So when a yarn is produced in a manner that is not produced by any other cloth maker, can be patented. But when it comes to for making a format in which the yarns are like set up in in a different format, and then a net is created out of it, or some other design is created out of it, that does not count into fabric design or fabric base. So there's a very thin line in going into copyrights or going into for patents for a particular product. So a fabric of a new innovative kind can also be patented. As we all know, firstly, we used to have this kind of cotton fabrics that were only made out of the cotton flowers that we had. Then came the silk fabrics. So those are two different kinds. If now something else, polyester is created. Now if something new is the base material of a fabric, that can be definitely be patented. Moving ahead. Sir, can you please change the slide?
Madam, it has been already been changed. Which subject matters are patent? Human
Hello.
genes. Hello, audible? Am I
So
audible?
moving ahead, like if I
Madam,
may explain about the copyrights.
Madam, this
So
is
the
related to.
we can obtain copyright.
Hello. Hello. There is a general Advocate.Jinal. Can you hear me? Madam, unmute yourself. Madam, unmute yourself.
Yes,
Okay.
yes.
Madam, this is related to medicines as well as the sporting equipment, which is still there, including the human genes.
Definitely, definitely. I'm so sorry for the bandwidth error. Maybe I
No
have
problem,
some
madam. Please continue.
right now. The subject matter and applicant can receive patents on human genes that meet certain scientific requirements. So we all know we were amphibians at the time. We had some other kind of genes, and then as as we all know right now, and each and every thoda bacha also knows that coronavirus has mutated itself. So how did coronavirus mutate itself? Because of the change in genome as it went to human to other human. So if there is a kind of genome that is found out by someone, and if there is a kind of mutation that has not appeared naturally, but that is curated by a scientist or by some person, that can be patented, and which can be beneficial to the society. So such genes are normally used to cure some diseases if there are, and the genes can also be used to increase the capacity of a human. So these are the two
Madam, I
examples.
like to ask. Madam, I like to ask the question related to man-made but not naturally occurring bacteria. If that bacteria is harmful
Yes.
to mass at large, that means
Mhm.
the register won't be giving them the license to get the patents. Am I right, ma'am?
Absolutely, you are right. But in case of bacteria, there are certain bacteria that are good bacteria, and there are certain bacteria that are bad bacteria. And
Okay.
again, there are some bad bacteria that are used to cure diseases because they travel in a certain speed that can easily help cure diseases rather than using good bacteria. So when it comes to bacteria, they can definitely give a patent if there is necessity, but they can give some restrictions as well as to the supply of of the amount or to the people in the format in which it is necessary. So there are chances that it might be granted, it might not be granted. Then coming everywhere, each and everywhere, it is very necessary to keep in mind that anything that is naturally occurring cannot be patented. It has to be, it has to have human interaction with it, and it has to be something intellectual. Basically, it's crystal clear. Intellectual means something out of a human mind. So anything that is naturally occurring apart from it cannot be accepted in patents. Then comes medicine. Of course, medical industry is so vast because of this one law. And it has to be a motivation for each and every medical professional to create new medicines and innovative medicines that can firstly help the society definitely, and secondly give an impact as to, yes, their richness should increase along with the health of the society. So medicines can be patented, sporting equipments can be patented. There are now chances that uh, like a special person who is missing some body part can also be a sports person, because there is a kind of innovation that they can have a leg in place where they didn't have a arm in place where they didn't have, or even if they don't require that kind of a support, then a equipment is created in a way that a person who is sitting in bed can stand up. So, or everything, including uh, the innovation, the equipments that are used to treat patients who cannot stand up by themselves or who cannot move by themselves, can be registered as patents.
That means, ma'am, the special types of wheelchairs or the special type of treadmills which are beneficial to persons at large, and those persons who are watching this video currently, they are aware they might have got the patents registered, including the medicines which is helpful for the cancer patients or or to the persons who are having suffering from disease, including the EEG machines or the ECG machines or the MRI
Absolutely.
or the CT scan machines. I
Absolutely.
think that particular machines who are there with pathological laboratory or the
Hmm.
radiologists who are using these machines, they are also aware these machines are getting their patents registered. Coming to the next slide, ma'am.
What is not patentable? As I already mentioned, mere discovery of something that is already existing free in nature is a discovery and not an invention. That is like an innovation thing coming out of intellectual intellect of a human being, and hence cannot be patented unless it is used or processed and manufactured as an article or a substance as a whole. I mean, as I already mentioned, there has to be a certain level of human interaction that takes place before it being a final product to be used by the society. For instance, a mere discovery of microorganism is not patentable. Absolutely not. With subject matter again frivolous or against established natural laws, something that can harm the society, or something that is as petty as being a common knowledge or not even required to the society, cannot be patented. It should be of a legitimate use by the society and the members of it. Harmful to human and animal health, absolutely that cannot be patented. And again, in some cases, if a medicine is taken in a wrong format, it can be harmful. So the merits have to be more and the demerits have to be lesser, such that if medicine is used in a format in which it should be used, then it is not harmful. But in the first instance only, if a product is used and it is harmful, then that cannot be patented at all. It cannot be harmful to the nature, it cannot be harmful to humans, it cannot be harmful to the society as a whole. Scientific principles or formulas, mathematical formulae, algorithms, etc., that cannot be patented. It can be copyrighted in some instances, but cannot be patented because it is of the use by the people and for the people, technically. The discovery of new properties and substances already known. I don't know where does America exist, and suddenly I find out, and then I start claiming that I found out the thing. No, that is not possible. It is just a discovery. It is mere discovery by me. There were already things existing, and it is not due to my innovation or invention that thing is now arise in the environment. So that cannot be taken.
Advocate.Jinal, could you, before concluding the session, could you throw some light on the recent case laws related to copyright, patents, designs, or trademark? The recent cases, in short, that would be beneficial for those persons who are hearing on the World Intellectual Property Rights Day. If
Absolutely.
yeah, ma'am.
Absolutely. So right now, the biggest example can be of Tesla, that we are all fans of, and it's very, in the limelight because of its Twitter, uh, Tesla Twitter case, that it want to take over the Twitter handle. So everything, including from the basis of it, the Tesla is continuously patenting and copyrighting its innovation every second day. And even if it is not, then whoever breaches it is highly rewarded for it, because they are trying to find out the things, the people who can make such things for them. And there is the best example is of Coca-Cola. We all know the shape of the bottle. The drink, the color of the drink itself is a trademark for Coca-Cola. We all know about the when you visit an Apple store, we have all experienced a certain kind of setup that the Apple stores have. When you enter the store, it is not like any other stores that we are entering. There are tables in the center. There is a certain format in which the phones are kept, so that it is actually easy accessible and very informal in nature. So this is a kind of business setup that they have, like, taken their intellectual property right on. It cannot be used by some other stores, and some other stores cannot put a replica of it. There's a kind of aroma that you feel at certain stores like Starbucks, CCD, this Apple itself. Then there is Zara. When you enter, you feel a kind of aroma. So that aroma itself is a copyright. They cannot, the other perfume companies, everyone else cannot produce such kind of aroma unless and until the term of copyright expires. So if there are perfumes, then the perfume can be copyrighted, and it comes under the same class of it. The symbol of McDonald's, every other symbol that we see in the market right now are trademarks of some other company. Now the question will be, like, if copyright have limited time, if patents have limited time, then do trademarks have limited time? No, not at all, because trademark is for enjoyment of the trading entity itself, of the company. It is not for the enjoyment of an individual. It is a brand value that is created, and hence the trademark is granted to a person. So any trademark that you see cannot be waited for in expiry and some other person can use it. But when it comes to patents or copyrights, you can definitely wait for an expiry of the patent period and then start producing the same kind of products in your own market. So the other case laws that I can easily, if you want to easily relate to it, that I can right now say is the kind of cloth that is used by Raymond, and the texture that is provided by it is copyrighted. It cannot be. There are many case laws, but then I on YouTube don't want to actually give out the.
Okay, Advocate.Jinal. Since ma'am had rightly explained about the trademark, we have the trademark related to the bottle which has been given for the distillery or for the Coca-Cola bottles, or the designs which has been registered of the watches, or the shapes of the bottle, or if you see the ICA or ICISI, that is Institute of Company Secretary of India, they have their own the service marks which has been registered, logos are been registered, and the if you come up with the copyright, the original works or the songs of the Lata Mangeshkar or the original painting of M.F. Hussain or the original music of A.R. Rahman, or if you see the his master voice in great olden days of HMV or the Saregama, and if you see the many serials are doing their own copyright, like the Neela Telefilms, Tarak Mehta, or the old serials like CID or the Boogie Boogie. And if you're coming over with the particular part like designing of the lehengas of Manish Malhotra, or the designer sarees of Parag sarees, or any of that particular, rightly you pointed about the petas of Agra's, Kolhapuri chappals of Kolhapur, or the Mahalakshmi Chuda, or if you see Tirupati Devasthan's the laddu which has been patterned, if you see Lal Bagh's Rajas, the particular the face of Ganpati is been patterned, and if you see the Pitambar of Lal Bagh Raja has also been patterned by that particular community of Lal Bagh. So rightly, the S.S.T College of Arts and Commerce has organized on this particular World IPR Day, or that is 26th of April 2022, for the mass scale to understand the needs and wants of the intellectual property, rightly pointed out by Advocate.Jinal Shah, who had appeared at the Supreme Court various occasions, and she had also appeared for many family courts as well as for National Company Law Tribunal also. And on this particular day of IPR, on behalf of the S.S.T College of Arts and Commerce, my respected principal, Dr. J.C. Purushwani sir, IQAC coordinator, Khushbu Purushwani ma'am, the assistant professor and HOD of BMS department, Assistant Professor Padma Deshpande ma'am, myself, Advocate Professor Sunil Shah, would be giving you thanks for giving us the time and rightly explaining related to the IPR. From my side, I'm declaring this session is over. Thank you from all.
Thank you so much. Thank you so much, sir. Thank you so much